legal concept, isn't it? Those who are most responsible. It crept into the UN language at Sierra Leone where they wanted to limit the number and they spoke of those most responsible. But organizations like Human Rights Watch were very concerned, Serge Bramets, that the people who did the actual killings would get off. Is this the class of person that you want prosecuted now? Serge.
As we all know, there has been a certain evolution in time in terms of the notion and who is the main responsible and who is not. And if we see today the evolution in the region where mainly physical perpetrators are prosecuted, but where you have also more and more middle-level people prosecuted and investigated. I think that's a very positive evolution. As you know, as an important part of the completion strategy since 2004, a number of cases have been transferred to the region based on those principles of most responsible or middle-level perpetrators. There have been several decisions by judges to decide what case can be transferred to the region and what case had to stay in The Hague. What we have seen in the last 2 years from the Office of the Prosecutor, since 2004, there was no possibility anymore to indict people. We have transferred investigative material in relation to 43 other suspects to the region. We finalized this process only 2 months ago, whenever indictments had been prepared by the tribunal.
But what standard do you use to the cut-off point between those who deserve prosecution and those who could be left perhaps to provide evidence to a truth commission? How do you determine the level of responsibility that, given the difficulties in financing these courts, those persons who should escape prosecution?
I think the legal situation is quite clear. For the so-called 11 bis cases, which have been formally transferred by the tribunal, their judicial proceedings have almost been completed. There is no alternative to the judicial proceeding in the region. The so-called Category 2 cases, as we call them in our internal proceedings, and we have a transition team, a number of colleagues only dealing with collecting this material and transferring it to the region. It's up to the local authorities to decide. Those are sovereign states with independent judiciaries, and they have to take their own responsibility in deciding if there is enough evidence and then the case is important enough to go before their own national jurisdictions, or if another approach is selected. So I do not see any contradiction with on one hand having, of course, an important number of prosecutions still going on, but on the other hand, we know that with thousands of potential cases in Bosnia, it's impossible to handle all cases in court. That there are other mechanisms put in place, I think it's a very positive evolution.
But where do you put someone, for example, and there are tens of thousands of them who are part of a platoon or a brigade that is ordered to kill and does kill, in situations where it must be obvious that a war crime is being committed? Are they Category 2? Do you leave them to the local authorities? Or do you suggest that they are, as it were, truth commission material?
No, I don't think that as a tribunal or as Office of the Prosecutor we are expressing any preference in the way local authorities have to handle it. I fully trust in the leadership of the prosecutors and the president of the tribunals in the region to take the best possible decision based on the cases presented there. I think it's important that we are not trying as tribunal so close to the completion to try to play a role in cases which are not under our jurisdiction, where we have no legal authority to do so. Mm-hmm. What we are doing on a daily basis is to answer requests for assistance coming from the region, because of course we are not sending this material and then it's over for us. We are receiving on this material many requests for assistance, which are often handled by the liaison prosecutors in our offices to strengthen their judicial cases. And so far, the Truth Commission is one option which is discussed today, but as far as I know, today the judicial option is the main one. But as I said, it's up to the local authorities to decide.
Tomislav Bisnic, is this the kind of decision that you are confident will be made by local prosecutors sensibly and determinedly?
It is difficult to say from the position of a defense counsel and assess what the decisions of local prosecutors may be.
Perhaps you could speak in English.
Yeah, I said it's very hard from position of defense counsel to predict what will be the action or reaction of prosecutors.
Mm-hmm.
What we believe is, I will repeat again, that the defense has to be incorporated in a system there to put right input in fair trials.
Mm-hmm.
If those trials will be executed in the national countries.
Thank you. We've spoken a lot about the effect on the legacy in relation to the countries of ex-Yugoslavia. President Robinson, what's your hope or vision in relation to the legacy in the wider world?
Well, we deliberately confined this conference to the legacy in the former Yugoslavia, and we very much hope to have another conference next year on the wider and more global legacy of the tribunal, because that is indeed very, very significant. And that legacy is in several areas. One area in which it will loom large is in procedural international criminal law. The tribunal, as you know, has had to develop many, many procedures, devised many procedures to expedite trials without prejudicing the rights of the accused. The other area is in the substantive international criminal law, substantive jurisprudence, where the contribution will also be immense in areas such as the law relating to genocide, the law relating to rape. All of these are areas where the tribunal has made tremendous advances in
So you've got the jurisprudential shadow of the, or footprint of the tribunal. You've got its impact in showing that international criminal law is not only concerned with Africa, and is concerned to protect Muslims, and all of those international aspects are going to be the subject of a conference next year.
You're absolutely right. International criminal law is indeed global, and we, of course, reject any notion that it should be confined to one area of the world, whether it's Africa or anywhere else. But we hope to look at that issue next year.
Good. Right. Now, ladies and gentlemen, it's your turn to ask questions of members of our panel. We have some roving microphones, and they will come to you when I indicate. It may be, I think it will be a good idea if we take 3 or 4 questions at once, so that will save time. But there is a question there and a question there, 2 quite close together there. We'll start with you two, and a third one over there. If you just give your name and any organization to which you belong that's relevant, and ask your question.
I'm an activist. I'm a human rights activist from Serbia. And I have a question for Prosecutor Brammertz. He stated on 2 occasions that he placed great trust in national prosecutors, that they were experienced professionals. I agree with him in part only. I will give you an illustration right away, and I expect Mr. Bramets to answer this. In February of 2008, in a case before the tribunal, a witness appeared and testified. On examining the audio and video recording of the testimony, one can clearly see that the defense witness was groomed by the local prosecutor. One can also see that the witness was a participant in the commission of the war crime. Judge Bonamy was seized of the case. He cautioned the witness, and in accordance with the rules of evidence and procedure, he immediately advised the witness that he should hire an attorney and that whatever he stated could be used against him. What one would expect out in the field, in the region, in Serbia, is that the witness would be brought to justice, that he would be tried. This did not happen. And is there anyone who is part of the tribunal who keeps track of that? I don't think so. What I want to point out is that this link does not exist. This basis which would help transpose the responsibility for the prosecution of war crimes from the ICTY to the local courts. What will follow unless there is a residual mechanism which will serve as a control?
Because I have a question now.
Yes.
Because slušali smo I Pierre Mirella I
We listened to what Mr. Pierre Mirel and Judge Robinson had to say, who understood very well the fact that there should exist a mechanism which would create the bridge between the ICTY and the local courts. Please, if I may.
You have had.
Nama je potrebno ovdje da znamo.
What we need to know is what is the controlling mechanism.
Find out when the question is passed on. Can we have the questioner behind you, please?
Molim, samo da polim. Nama je potrebno da znamo.
Can I just finish? We need to know what sort of residual mechanisms will exercise control of information and evidence and knowledge transfer from the ICTY to the local courts. That is the basic question.
When he answers your question. Yes, the questioner behind you, please. The lady in the red. Okay.
Želim svih da vas pozdravim.
I wish to greet everyone present here. I am one of the victims of thousands and thousands of women victims of rape. My name is Bakira Hačić, and I am the president of the Association Women Victims of War, gathering women who were victims of sexual crime and violence in Bosnia and Herzegovina. So I gather women of all ethnicities, Bosniak, Croat and Serbs, because crime transcended all ethnicities. My question is for Judge Robinson. We should like to know when the UN Security Council will shut us down. They have been doing this for the past several years. We want to know when exactly the ICTY will close down in order for discussions to continue on the legacy and the archives of the ICTY.
Thank you. And the third question over there.
My name is Ivan Zvonimir Čičak. I am the